And if I can just add, there's actually been studies about how employers comply with the FMLA, which is a similar law, and paid family leave. And most employers are able to arrange coverage by shifting around work assignments the same way they would do if someone was out sick or something like that. And even though the law does allow for a maximum of 12 weeks of leave, that's only if that entire time is actually medically necessary or that entire time is actually used to bond. And so in many circumstances, we're talking about a much shorter period of time.
Well, again, the balance for me at that 25 is really an imbalance, number one. And number two, I don't think it really does take into consideration the real world circumstances, but beyond that, I think I would agree with you that when businesses on their own, with a good staff of employees and a good relationship, they do have circumstances in which, and I've been in business a long time and have done the very kinds of things, but there's a huge difference between a law that carries with it an absolute, you will do it this way, or else you will have a threshold of litigation and all kinds of penalties. I would argue that is more of a discouragement than an encouragement, and would suggest that this may even create some angst in a workplace that would be an unintended consequence of all of this. And for those reasons, I'm going to have to reluctantly be a no vote.
Appreciate it. I know that, in those states where they have this, that has not been the circumstance, and I have more confidence, I suspect, than in the business community for being able to adapt as well. And I think that is all this calls for. It would be wonderful in a perfect world if all employers were like you and like to think like me, being accommodating as well. But there are many employers who are not willing to recognize that, and this is just an effort to really bring that to the consciousness and to the culture as we see more and more people in the workplace. California is the second most multi-generational state in the country, meaning that we have more families who live generationally than anywhere else but one state, and I've got to figure, I can't remember which state that is. But so, again, sort of adapting to the realities that we experience. This is, I believe, a modest but important step in reaching that goal. So I appreciate it, Assemblyman.
Thank you. I see Mr. Thurman has a question as well.
Thank you, Mr. Chair. I actually would like to ask a couple questions to those who testified in opposition of this bill, the Chamber and the Ambulance Association. If you will allow that, Mr. Chair.
Yes, of course.
Thank you. I'm looking at this bill from the lens of someone who's had to take time off to care for a family member, and from the lens of what I think is really good family values. We define our families by grandparents are in our families. We don't throw them out. We ask our grandparents to take care of our children so that we can work, or so that they have the benefit of access to their grandparents. And so from my standpoint, this is just an extension of that for other family members, and that in many ways this could create some savings for the state. If someone can't get the time off to care for extended family, grandparent, domestic partner, they may very well be forced to put that family member into an institution that's going to cost more for their care. But I want to ask you about some of the things that you said in your testimony on behalf of the Chamber, and I think it relates to some of the questions from my colleagues about the number, the threshold number for businesses. And I get it. We want to do things to support our small businesses, right? 60% of our jobs come from small business, and so that's important to us. But if that's the case, by doing this, don't we expand an opportunity for more Californians to have the ability to take leave by expanding from 5 to 25? Don't we create more opportunities for more Californians to be able to have the opportunity to have these types of benefits?
Thank you, Assemblymember Thurman. Absolutely. If this bill is to go into place, you will be expanding the opportunity, I would suggest the mandate for employers to provide a 12-week leave of absence. But we believe that that will create a lack of balance in the workplace for these smaller employers that can't sustain a 12-week mandated leave of absence, especially without consideration to what else is going on in the workplace. So as I mentioned before, it's a mandated leave of absence. You don't get to take into consideration whether or not there's other employees who are also out on a similar leave of absence, or if you've given a personal leave of absence to somebody else. You don't get to take that in consideration. You just have to do it. And so that's for my concern. It takes it out of balance and creates this huge burden on smaller employers that they can't sustain.
Can't this, though, be mostly cost neutral? And I'm going to say completely cost neutral because I'm sure there's going to be some incurred costs if, as the senator states, the company can bring on a temporary employee, or maybe a better term would be a short-term employee,
Sure.
For 12 weeks because these benefits are non-paid by the employer. Can't this be somewhat cost neutral in that the employer can bring on a short-term employee for that duration using the savings that they would be achieving from the employee who was on leave to help offset whatever costs they would incur to bring on the short-term person? Doesn't this create some opportunity to be almost cost neutral?
I guess I could disagree with you on that point. I mean, for some industries, it may be relatively easy to find a temporary employee to come in and fill the position. If it's an administrative assistant work, and I mean no disparagement to any of those employees, that's something that a lot of employees could come in, and our temporary workers could come in without significant training from going to one workplace to the other. Not suggesting that they wouldn't have any, but I'm just saying it may not be as specialized as other industries where you actually have to have training, skill, and necessary experience in that particular field, in that particular industry or occupation. So it does create a challenge for some of those smaller employers who have a unique workforce where it's not easy to find a temporary staff. So then what do you do in that situation, right? You're either paying a lot more for a temporary staff because it's a limited opportunity, or you're spreading it out to other employees that may have other burdens going on, other family balances that they're trying to adjust to, and asking them to work additional hours in time, and you're paying a premium rate for that. So I don't know that it's totally cost neutral. And then, of course, from our perspective, it opens it up to litigation. It is not as easy as just saying you get 12 weeks off. There's certification, medical documentation that you need. You need to track it for administrative purposes. A lot of these smaller employers don't have a dedicated human resource person to sit there and track every employee's hour while they're out on leave and to make sure that the necessary paperwork is considered. So I think that that is also an added burden to a business who's just trying to operate a business and not in the business of actually working through all the legal requirements of the California Family Rights Act.
I'm sensing that the Ambulance Association wants to speak to this example. I'm getting eye daggers. I'm sensing that there's some interest.
No eye daggers at all.
That was a good example that Assemblymember Patterson raised, that an EMT is a harder position to fill. But I thought I heard recently that there's some unemployment for EMTs in California, and that there might be someone who is looking to work who might be able to take a short-term position.
That very well could
but I don't know
be,
your
but
sector,
I guess your
so.
fundamental question
Yes, sir.
about cost neutrality, I guess, as Ms. Barrera indicated, that assumes, of course, that the cost would be precisely the same, and you may pay, for example, as she indicated, a premium for someone who is coming in on a short-term basis, whether it's the full 12 weeks or less than. And again, I think the costs associated with administering the program also has to be taken into consideration, especially with the smaller employer. I can't imagine many 25 to 49 employee businesses that have a truly dedicated full-time person who is able to track this in 1 hour increments.
And I agree. I don't think
it may
it's
be
100% cost neutral, but I think that there are some offsets to reduce it. And I guess I'll just close with this. I know that when I've been given the opportunity to take leave to care for a family member or a sick family member, I know that that has generated a kind of loyalty, support, and excitement for me to work even harder and to demonstrate even more value and to look for more productivity, if it's possible, to generate more from my employer, to say I appreciate being valued. You know, I've managed people for a little bit, and I think, you know, the example that was given today, that someone lost their job because they asked for 6 weeks, and I thought to myself, it takes much longer than 6 weeks to even train a new person. Why not guarantee them their job to be waiting for them, even 12 weeks? I mean, let's face it, I may not learn this job for 12 years, right? But 12 weeks, the amount of time that we'd spend training a new person, isn't it worth it to give someone the 12 weeks and to say, you've got job security waiting for you? Yes, we may have a short-term person, but your job will be here for you at the end of those 12 weeks. And that I think we'll see the productivity from that person because of their appreciation to their employer supporting them during that time of leave.
I'm sure that was a statement, and I don't necessarily disagree with anything that you just said. I think that the small employers, I know that there was that example, and it's a horrible example. But there are a ton of small employers who are doing that right now, probably doing better than that. They just don't have the threat of litigation and the administrative headache that this bill will create for them. They're doing it on their own goodwill and because they want to make sure that their employees are happy and are loyal. I don't disagree with you. But this adds a whole other component of administration and litigation that they currently don't have to be subjected to.
Thank you both. Thank you.
Looks like Vice Chair Harper has a question.
Thank you very much. Comments that I have in regards to this one is, my concern with all these new folks that are eligible for 12 weeks, that, the problem that we have is the potential for subject to abuse. And, we're already having a lot of problems, especially in Southern California areas, in terms of work slowdowns. And this looks like it could be a way to be able to operate a new avenue in order to produce work slowdowns. Another thing, which is tricky, is you have how many new folks with these 12 weeks, whether it's the new people that are eligible because of all of the new relationships that are eligible, or whether it's because of how many new businesses are eligible. How many people are we taking out of the workforce, out of the economy? But the difficulty is that because it's not a new permanent position available, that we're taking a lot of people out of the economy potentially without turnover for new people to be able to move into those jobs. And so that's an additional concern of mine. Additionally, I'm very sympathetic to one of the arguments that was set against in terms of the logistical nightmare, in terms of being able to keep track of these up to 12 weeks when it can come down to increments, whether it's an hour or whether it's multiple. It looks like it's a real logistical nightmare, and it could be an even bigger logistical nightmare if the people who are at the human resources departments also are taking advantage of the 12 weeks in the most difficult way to be able to manage as possible, especially. And so with a lot of those concerns, again, I'm very concerned about how we're making California a less appetizing place to start business.
Okay. One more quick question,
Just
please.
Still on the 5, right?
No, just a comment. Look, believe me, I'm sympathetic, and I really am understanding. But in the world I've been in for 30 years, it is conceivable that a business of 25 or 30 employees, if they were to have 3 or 4 or 5 employees take what they have in law and do it because it's a right and a law with huge consequences. It is a significant threat to the viability of that very business. With the threshold set at the 50 and with the, I think, good history of employers and employees in these smaller businesses to work through these kinds of things, it is perfectly conceivable that those same 3, 4, or 5 individuals,
Thank you.
without the hammer of the law, would have worked through that issue, probably because they had a joint interest in the viability of the business itself. And so, for me, it's the balance, the difference between the hammer and a velvet glove, and between coercion, force, and cooperation. That's the dilemma I'm facing with the bill.
I appreciate that, and if there were good history and this weren't a problem, I don't think we'd be here. I'd like to remind you again that 12 weeks is the maximum, and it's unpaid. So you have to have employees who can financially stay out of work for 12 weeks. That's 3 months of not getting a paycheck. There just aren't a lot of people out there who can do that. So that's one of the comments. conceivable, there's so much in life that's conceivable. The fact is that in the states where this exists, they haven't been having those problems. The fact also is that when people take the time off, it has to be documented that it's legitimate. So this 1 hour at a time might happen once in 10,000 examples. It's not the norm. It's not what's going to happen. People need to show there's a medical necessity for it, or that they've had a new baby. I mean, there are very limited circumstances when this applies. And most people, by the way, who take that leave, it's usually for their own health. That has to be documented by a physician. So we're looking at people who are just trying to take time so that they can sort of pull themselves together, or they can bond with a new child, or they have a grandparent or a grandchild that is living with them, or this woman. There are a lot of these stories. It's extraordinary how the fragility and the instability of knowing just how, whether or not you're going to be raising your grandchildren, if something, God forbid, were to happen to your children, or whether or not even God forbid, your children come home to live with you. That happens too. But we recognize that families are a complicated situation in today's world. And the last point, and I will use that as my close, is that the costs, and they are of concern. When you lose employees, when they say, I can't do this, I can't work at home, and then get a call that grandma's drifting out into the streets because she has Alzheimer's, and her caregiver there's no caregiver there. And so people quit their jobs. The cost of hiring and the cost of retraining people is frequently an exorbitant cost. And I agree with you, Assemblyman, if employers could sit down with employees and work this out together, that would be the best of all possible worlds. But that isn't what is happening. And I think that's still, again, you don't have to ask for 12 weeks of leave. You don't have to take 12 weeks of leave. If you can work with your employer, and again, it's unpaid. So I think just business necessity, I just think economics, few people are able to take the 12 weeks, but it's there because we want to say as a society that we respect families, that we respect the responsibilities that you are willing to undertake or have to undertake as a family member, as a new parent, and with that, I would ask for your aye vote.
Thank you very much. We do have a motion and a second on this bill. So with that, Madam Secretary, would you please call the roll?
Motion is due pass to appropriations. Hernandez?
Aye.
Hernandez, aye. Harper?
No.
Harper, no. Chu?
Aye.
Chu, aye. Low? McCarty? Aye. McCarty, aye. Patterson? Patterson, no. Thurman? Aye. Thurman, aye. That bill is out.
That bill is out. Congratulations, Senator. Up next, Senate Bill 579, time off related to school activities.
Mr. Chair, if I could, I'm being pressed to go back and vote in Senate Labor so I can vote on bills from the chair of this committee.
Yes. Happy to allow you to do that.
Could we take 5 minutes so I can run down and vote and then
Happy to
come
give
back?
permission to your staff to present, if you're comfortable with that.
Would that be?
Yes,
would that
permissible here.
be your preference?
Yeah.
All right. Permission requested?
Granted.
Permission granted. All
As
right.
long as permission is mutually granted.
You bet. Okay, thank you.
Thank you, Senator. Good job. Your escort is awaiting you, Senator Jackson. Okay. You're looking quite senatorial.
Thank you, Mr. Chair.
All right.
Chris Reef on behalf of State Senator Annabeth Jackson.
Welcome.
I'll be brief. This measure takes a necessary and practical step towards modernizing the California Family School Partnership Act, which allows parents to take up to 40 hours of unpaid leave in a calendar year to participate in their child's educational development. SB 579 will make two modest yet important changes to this act to allow working parents to utilize their existing ability to take an unpaid day off of work to, one, enroll their child in school or in a child care program, and two, to respond to an emergency in their child's school or child care program. And in being brief, the bill has come a long way since the Senate. And at that time, when the bill was heard in the Senate, it was opposed by a number of employers' organizations. After weeks of meetings and discussions with the opposition and others, the senators reached agreement on amendments which removed all opposition. The Senator is proud of this effort and sees it as emblematic of that workplace protections and economic development can go hand in hand, that labor and business can work together, that it is not an us versus them scenario, rather that when we work together we can develop mutually beneficial policies that reflect the needs and values of working families and businesses. Thank you for consideration, and on behalf of the Senator, I respectfully ask for your aye vote.
Thank you. And with that, your first witness.
Hi, my name is Julia Parrish from the Legal Aid Society Employment Law Center, and I just want to underscore that this is a reasonable measure that allows employees to use time off that they already have, existing time off, for additional reasons that aren't currently included in the reasons that those employees can take time off. So this really gives families the opportunity to find the appropriate child care or school for their children and deal with an unexpected unavailability of a child care provider using only existing provisions of time off that currently just have a more narrow definition of reasons that people can use them. The second thing that this bill does is bring into alignment the KinCare Act with the Paid Sick Days Act. It does not add any additional paid sick days or paid sick time. The KinCare provisions are existing labor code provisions that allow employees to use some of their paid sick days to care for other family members. And so this is bringing those definitions of family members into alignment with each other and also adding preventative health care to the KinCare definition, all of which are definitions and uses that are already permissible in the paid sick days law. So this is merely bringing those two laws into harmony to allow families to use time off when they really need it. And most children now live in homes where both parents work, compared to just 33% of children in 1976, and a third of families with children are headed by single parents. And so it's really important that we allow parents to help be engaged in their children's school and child care activities, and for those reasons we ask for your aye vote.
Thank you very much. Next witness.
Good afternoon, Mr. Chairman Hernandez and members of the committee. My name is Lori Furstenfeld, and I'm a staff attorney at the Child Care Law Center. We are a legal nonprofit agency that helps low-income families obtain and keep their child care. We'd like to thank Senator Jackson for her leadership in this area. I'm also a former social worker who worked in a mental health classroom in Oakland. And when I was in that position, I witnessed many times parents face the hardship of attending to their child's needs at school in crisis and choosing between their job. Many parents were not able to take off during times when their children really needed them at school out of fear of being fired. At the Child Care Law Center, we also just received a phone call from a mother who was fired because she needed the time off to evaluate the appropriate school placement for her child with special needs. She knew that she simply just could not enroll her child in the local school. She needed to find a program that supported her daughter's needs, and unfortunately she was fired for making that decision. In closing, we feel that the workforce has not kept up with the needs, or the workforce has not kept up with the current needs of their employees, especially low-wage earners, and we respectfully ask for your aye vote. Thank you.
Mr. Chairman and members, Dolores Duran Flores with the California School Employees Association. We're also here in support of this bill. We're here in support not only for my members to be able to take this important leave, but they actually work on school campuses, and they also provide child care. And it's very critical for them to be able to have parents come pick up the kids when there's an emergency, or if there's a behavioral problem, or if there's going to be a closure, because what are you going to do with the children during that time? So my members are left in those difficult situations as well. So we think it's very important to allow parents to be able to use protected leave in order for them to go and pick up their kids. And we ask for your aye vote.
Thank you, Mr. Chair. Members, Mitch Seaman with the California Labor Federation, also here in support of the bill. We think these are very modest, very minor reforms to existing leave allowances that will have little, if any, effect on employers, but will make a world of difference to affected workers and parents, and we urge your aye vote.
Thank you. Any other additional wishing to add on?
Good afternoon again. This is Mariah Watson on behalf of the American Civil Liberties Union of California, and we're in support.
Sue Miller, AAUW, California, in support.
Raji Prasad from the National Association of Social Workers California, also in support.
Jenya Cassidy, California Work and Family Coalition, in support.
Jennifer Reich, Equal Rights Advocates, also in support.
Any additional wishing to add on in support? Seeing none, any of those who are wishing to speak in opposition? Seeing none wishing to speak in opposition, we'll go ahead and proceed to members' comments, questions, or motions.
I'll move.
Second. Okay, there's a motion and a second. Are there any further comments, questions? Seeing none, would you like to close?
On behalf of the Senator, respectfully ask for your aye vote.
Okay, let's go ahead and proceed with vote.
Motion is due pass to appropriations. Hernandez. Harper. Harper.
No.
Harper, no. Chu. Chu, aye. Low. McCarty. McCarty, aye. Patterson. Patterson, aye. Thurman. Thurman, aye. That bill is out.
Okay, vote is out.